Good evening. This is Rahul Magan here as a Group Chief Executive Officer, Treasury Consulting, and also doing LLB. Today, I wish to explore a very interesting concept. And unfortunately, even after this interesting concept, the things are status quo. I don't think I need to explain the definition of the status quo to my subscribers. But first, let me tell the interesting things. When it comes to the money laundering, when it comes to the tax havens, I never said that India do not have laws. India have laws, like we have PMLA, Prevention of Money Laundering, 2002, we have this law. We have a law which is law of black money undisclosed for foreign assets. We have this law. We have law pertaining to Securities and Exchange Board of India, SEBI, we have this law. And in all these laws, there is one common thing, which is agreement. Now, what is that agreement? That's more important. Now, that is that the agreement is not an agreement between the person who wish to have his money laundered, probably in some tax havens. Here, the definition of the agreement means the agreement between the central government and the contracting state. I know that contracting state is a really technical term. Contracting state means a state, probably a country, where the assets of the party who is being investigated are laundered. So, example, let me again take a hypothetical example. I further repeat, this is a hypothetical example. If that example ends up being a real example, then this is a coincidence. Ramlal Chole Bhature, promoter Ramlal, who is a listed company, having stock price at 100 rupees, example, that person laundered his money in Switzerland. And for a minute, let's assume that income tax authorities, Securities and Exchange Board of India, probably Directorate of Enforcement, read with Central Bureau of Investigation, CBI, they are behind the promoter Ramlal to see where the hell is the money. Now, in this, we hypothetically assume that the funds are being laundered in Switzerland. It means Switzerland is considered as a contracting state, which means in this case, the Indian investigative agencies to be in touch with the Swiss agencies regarding the data. There are ample of provisions which we have almost in all stat, like we have CRPC 160A and 160B, which is called letter regulatory. We have many MLATs. Now, MLAT means Mutual Legal Assistance Treaties. I repeat, Mutual Legal Assistance Treaties. It means sometimes you would be helping India and sometimes the foreign countries would be taking the help of India. It's a mutual legal assistance treaty. Like in the case, Switzerland is a contracting state, because it's a hypothetical example. It may possible Ramlal Chole Bhature is a Switzerland-based company having FMCG business in Switzerland. And in this eventuality, they laundered money in India. In this case, the contracting state would be India, not the Switzerland. Histories witness that Swiss, Mauritius, Cayman Island, and many more are considered as a place for tax havens. Even Singapore is considered as a tax haven. Let it be very honest. And you can easily vouch from internet also. But tax havens is further categorized into two parts. And this is something I outrightly fail to understand, that why media is not talking about this issue. Now, here the tax haven means that one tax haven means I am laundering my money. So if I go with the hypothetical example of Ramlal Chole Bhature, it means that Ramlal Chole Bhature is saying that you would transfer your money to Switzerland, and Switzerland will create layers of the money and further repatriate this money in India in the form of foreign portfolio investors, foreign institutional investors, or probably private equity and venture capitalist firm. There is hardly any doubt about the fact that the foreign portfolio investors, foreign institutional investors are subject to multi-layer jurisdiction, which means apparently you feel that he is registered at Mauritius, but his one BO means beneficial owner, is registered at Cayman Island, and one beneficial owner registered at Caribbean Island, and final tick 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 tick, the final beneficiary owner would be at Singapore. But statistically speaking, officially speaking, that foreign institutional investors is registered in Mauritius. But having said that, we have a guidelines called SBO, right? Now, in this SBO guidelines, which is promulgated by MCA, which is called Ministry of Corporate Affairs, in these guidelines, it is the duty of that reporting entity, which could be a bank, could be a financial institution, or could be an intermediary, to even disclose the ultimate beneficial ownership, UBO. Now, keeping this as a backdrop, I would like to study a very important part of the money laundering undisclosed foreign income and asset, and that is the bill provides for a criminal liability. Please note criminal liability. The bill provides for a criminal liability with an enhanced punishment. Willful attempt to evade tax in relation to a foreign income will be punished with rigorous imprisonment for 3 years to 10 years and with a fine. Failure to furnish a return of income through the holding a foreign asset, failure to disclose the foreign asset, or furnishing of inaccurate particulars of foreign asset will be punishable with the rigorous imprisonment of 6 months to 7 years. The provisions will apply to banks and financial institutions aiding in concealment of foreign income or asset of resident Indians or falsification of documents. Guys, just tell me one thing. Do we understand the track record of few banks who are known for almost all kind of manipulations? You tell me one thing. Do not we know that few banks, those who operating in India, there is hardly any scandal they're not done with. Hardly any scandal. In fact, scandal must be thinking when they end up being a scandalous bank. This is the current situation of few banks operating in India. And they are licensed as AD1, which means Authorized Dealer 1 by Reserve Bank of India. And in public, Reserve Bank of India give a gyan about morality, about honesty, about integrity. But the banks who committed almost every fraud, they are approved by Reserve Bank of India as an authorized dealer one bank. More importantly, if I go further, I have an information that the central government has been empowered to enter into agreements with other countries, specific territories, associations outside India, inter alia means both sides, inter alia, for exchange of information, recovery of tax, and avoidance of double taxation. Now, let me take a break here and let me open the BEAR Act, the Foreign Portfolio Investors 2019. Bilateral member Securities and Exchange Board of India, Foreign Portfolio Investors Regulation 2019. Bilateral memorandum of understanding with the board shall mean that the bilateral member of understanding between the board and any authority outside India that provides for information sharing arrangement as specified in the clause 1b, section 2, subsection 2, 11, the main act, which is SEBI 1992 Act. Now let me go to the SEBI 1992 Act and go with the section 11. I'll show you something. Now, section 11, subsection 2, IB, calling for information or furnishing information to other authorities, whether in India or outside India, having functions similar to those of the board, in the manner relating to the prevention or detection of violation in respect of securities law, subject to the provisions of other laws for the time being in force in this regard, provided that the board, for the purpose of furnishing any information to any authority outside India, may enter into an arrangement or agreement or understanding with such authority with the prior approval of the central government. And Ministry of Home Affairs has signed many MLATs, which is mutual legal assistance treaties with many countries, and this information you can see in the public. Now my question is, when we have the power of MLAT, which is mutual legal assistance treaties, when we have the power of bilateral memorandum of understanding in the FPI guidelines, which is being promulgated by Securities and Exchange Board of India, then on what ground these scandalous banks who did almost every kind of fraud, they are not only operating in India, but also approved by Reserve Bank of India as an authorized dealer one bank? Think about that. Like I said, many videos on the cards, but you need to give me sufficient time. The reason being, to make every video, to edit every video, and then when you upload on the YouTube or the social media, it does take a hell lot of time. This is Rahul Magan signing off. You know my personal number, +91 9899 242 978. +91 9899 242 978.